virtual world, we understand that our device should be secure, but along with device, we also need to understand how we can protect our access and our data. And if we want to protect our access and data, we need to understand the importance of Data Protection Act. Elaborating the grounds for holding the provision as unconstitutional, it terms like annoying, inconvenient and grossly offensive used in the provisions are vague, as it is difficult for the law enforcement agency and the offender to know the ingredients of the offences. The bench also referred to judgments of a separate UK courts which reached different conclusions as to whether the material in question was offensive or grossly offensive. When judicially trained minds can reach on different conclusions while going through the same content, then how it is possible for law enforcement agencies and others to decide as to what is offensive and what is grossly offensive? The bench said adding what may be offensive to a person may not be offensive to other. The bench also rejected the assurance given by NDA government during the hearing that certain procedure may be let down to ensure that the law in question is not abused. The government had also said that it will not misuse the provision. The governments come and go, but section 66A will remain forever. The bench said adding the present government cannot give an undertaking about its successor that they will not abuse the same. The bench, however, did not strike down two other provision sections, 69A and 79 of the Information Technology Act, and said that they can remain enforced with certain restrictions. This section is all about civil liability. The criminality of data theft will be dealt with separately later under the section 65 and 66. Writing a virus software or sending a virus email, installing a bot, a Trojan or any other malware in the computer network or conducting a denial of service attack on a server all fall under this section and will result in civil liability. Computer virus, computer contaminant, computer database and source code are all described and defined in this section. In court cases like the Bazi.com case and others, questions like the employee's accountability in the organization sued for data theft or other offences, the level of duty of employer or the owner and the concept of due diligence were all disputed in the first few years of Information Technology Act 2000. As a result, the necessity to define corporate liability for data protection and information security at the corporate level became apparent. As a result, in the Information Technology Amendment Act 2008, a new section 43A dealing with compensation for failing to protect data was added. This is yet another watershed movement in the field of data security, particularly at the corporate level. According to this section, if a body corporate fails to adopt appropriate security practice and so causes unjust loss or gain to person, the body corporate will be obliged to pay damages as a compensation to the person affected. This section goes on to define the terms body corporate and a reasonable security methods and procedure as well as sensitive personal data or information. Thus, by adopting section 43A, which requires corporations to ensure the implementation of appropriate security methods, the corporate responsibility for data protection is considerably highlighted. Furthermore, the federal government specified what constitutes sensitive personal data in its notification of April 11, 2011, which include a list of all such data, including passwords, bank account, card details, medical records and so on. Following this notification, the IT industry in the country, including tech-savvy and heavily technology-based banking and other sectors, became acutely aware of the responsibility for data protection and a general awareness of what data privacy is and what role top management and the information security department in organization play in ensuring data protection, particularly when handling sensitive data. Reasonable security practice and procedure, site certification, security initiative, awareness training, conformance to standard certification, policies and adheres to policies, policy like password policy, access control, email policy, etc., periodic monitoring and review. There are some notable reasonable data security practice of various nations as Federal Data Protection Act Germany, Massachusetts Privacy Law 2010 US, Data Protection Act UK, Privacy Act Australia, Act on the Protection of Personal Information Japan. So friends, in this video we have seen various sections under Data Protection Act which can protect our presence online. Keep this in mind that we all need to protect our data at any cost because in this tech savvy world data is very precious. We can protect and access our data securely with data protection policy and procedures. Thank you.